Thanks also, I would say, to the strong will of Giovanna, we managed to be included. This is really an honor for me, and
My honor.
so it's a really a pleasure. And I don't want to spend so many words, just saying thank you for having not only decided to be part in this project, but to have worked quite hard in order to be punctual by sending the abstract and then the paper. And this, I think, is very good, not only for what will happen today, but what will happen later. Giovanna will say, I just say that there will be an edited book with a publisher, quite good, and the idea is to collect and to revise the books also in order to take into account what will emerge in, I hope, fruitful discussion. This is very important for us. Basically, we want to keep the paper, the presentation of the paper, not more than 9 minutes, in order to really enjoy the discussion among us, and we hope also with the person that will decide to join us later. So now I think it's time to start, and I will give the floor to Professor Minico, only after having remembered what his amazing academic score. She is a professor of constitutional law at the University of Naples, Federico II. She's teaching a research in the following fields: public constitutional law, fundamental rights, information and communication law, internet government, law of the fear, and independent authorities. She wrote many books. Two of them are really recent: Constitution, Emergency and Terrorism, and All Liberties and New Digital Borders. Many books, many articles, and it's forthcoming for a book with Oxford University Press about the regulation of the internet, constitutional issue, models, and challenge. I could continue, but I think it would be too much. So I would just give the floor to Giovanna, and in order to introduce the first speaker.
Many thanks, Oreste, and I want to thank all of you for your effort, for being here, for writing the paper, for having respect the time, for everything. I'm very happy to be here with Oreste and with you. Oreste, as I said, well, we have been working a lot because we think that this event could be a great occasion for each of one. We have the possibility to spread and to compare our ideas, and then, as Oreste has anticipated, but we talk about it in the afternoon, we want to do a book together. Now it's time to go straight to my introduction. In this introduction, I just limit myself to underline the key points concerning the relation between state of emergency and rule of law. It's time to start. I go there for my slides. I want to say that my iter precedenti will be divided into 3 parts. The first step consists on the general model of law of fear. The second step is occupied by 2 pillars, the directive of the European Parliament and the Council on combating terrorism, a very recent directive, and then the French law 2017 renforçant la sécurité intérieure et la lutte contre le terrorisme. In the final step will be my personal evaluation of the European legitimacy and effectiveness of the above directive based on the paradigm of the law of fear. What is the law of fear? The lawfare is an American paradigm, not mine, of course, but by Carl Sunstein. He wrote a very famous, beautiful, clear book. Its scope is to anticipate a dangerous event that, in the policymaker opinion, is likely but not sure to happen. This particular law aims to prevent that the risk of a future event will be converted into an actual damage. Its object is the compromise between the balancing of conflicting values. On one side, we find the fundamental right, for example, freedom of speech, privacy. I don't add anything more because some of your relation will be focused on these particular rights. This right may be legally squeezed in order to avoid the occurrence of a terroristic attack. On the other side, we find security, and the security need to be protected to avoid that the terroristic attack could happen. How can a balancing be pursued when the conflict interests don't coexist at the same time? I attract your attention on this point. In fact, the two values are misaligned for what concerns time. To a present and a certain damage, to a fundamental right correspond a future and hypothetical advantage to security. The criteria of the law of fear. A possible qualification of the law of fear could be a political issue, in my opinion, and I explain this because the legislator must refer to a criteria not well defined. These criteria present a high degree of discretionality. The first criterion, the precautionality principle, it guides the policymaker in his ex-ante prognosis of the risk. The question he must answer is, what are the actual chances of risk happening? It isn't a mathematical test, as I've written in this slide, given its inevitably controversial outcome. The two remedies, precautionality and proportionality. The first remedy. Do the principle of materiality and offensiveness require a detailed definition? The legislator must draw the new criminal offenses to take into account the double principle of materiality and offensiveness. Also, if he mustn't wait for the complete realization of the offense. What is an attempted crime? Our constitutional court has stated in a lot of decisions. In the evaluation of the attempted crime, he mustn't presume, the legislator mustn't presume the risk in base of the belonging of a person to a race or nationality, but he should check by a prognosis that the periculum is imminent, serious, and heavy. The precautionality principle implies that no legal evaluation of a presumed risk should be made. In this slide, I continue my speech on this criterion. Now we have the second, the proportionality criterion, as has been defined by the jurisprudence of the Court of Justice, and I don't want to add any more because a lot of your relations are focused on this issue. The key decision, as you know, is the Digital Rights Ireland concerned the Data Retention Directive and is a violation of the Article 52 of Fundamental Charter, and just to have, I have just reported the Article 52. Now some few words on the nature of this particular lawfare. Briefly, this kind of laws must have a temporary effect, i.e. a sunset clause, said American scholars. Sunset clause should be set. should be set also in implicit words, at the expiration of which the system should go back to the ordinary course. I usually say the system should be like an elastic band with capacity to return to its original state when the state of emergency is over. And now we have to see how the state could go back to its original status. Some words about the European law sphere, the Directive 2017. Just few words, because I don't want to anticipate what you are going to say, but I have studied a lot on this issue because I wrote a book, and so I wanted to say something from my point of view. The aim, the method, and the doubtful issue. The aim of this directive is to strengthen the fight against terrorism, and it uses as method to introduce new criminal offenses. For example, Article 5, public provocation to commit a terroristic offense. The three doubtful issues related to the above offenses. First, the violation of the legality principle that now has the dignity of a very high principle because is incorporated in Article 49 of Fundamental Charter, and Fundamental Charter, as we know, is incorporated in Treaty of Lisbon. Second, the consideration of attempted offenses rather than offenses actually committed. The person will be exposed to the risk to be punished more for his criminal intention than for what is going to do. The controversial question of the evidence concerning the criminal intention. And so we have to pose this question. Does the directive comply with the materiality principle? And I have to quote another article of Fundamental Charter, Article 49. And then another features, the safeguard clause of Article 23 of the directive, its formal coherence with Article 52 of Fundamental Charter. I can sum up that we are faced with the technique in Italian doctrine called, but also in European now, called the legal typical evaluation, already experienced by the President Trump with his order of ban against Muslim people, qualified regardless of terroristic evidence. I've said at the beginning that I wanted to have delved into two examples. The first we have already seen, European Directive. The second is the French Law 2017, renforçant la sécurité intérieure et la lutte contre le terrorisme. It is a very recent French law that has been designed to reinforce the fight against terrorism without, please, attention on this point, without recourse to extraordinary and temporary tools. What are their goals? Their goals, it doesn't prorogate the state of emergency, keeping the promise of President Macron when he was elected. He said, I don't want to prorogate the state of emergency. And so what is its nature? It's neither special nor temporary, because it wants to be a common law to cure, and it creates a lot of problem of legitimacy. What does the content deal with? If the goal is to let the state to go back to its original condition, the content go toward the opposite direction. And of course, we have to ask something about the compliance. Does it comply with the precautionality and the proportionality principle as defined by the judicial review? In this case, the fundamental rights are once more restrained on the ground of fear. What has changed in comparison with the previous French law is just the name of limit. In this case, just to give you an example, the searches have now been renamed. Now they are called in this new law visit, which have nothing to do with the doctor. The authorities can search places, computer, sites with all content. The worst thing is that all these limiting measures are not decided on the basis of strong evidence, but on merely vague allegation. So, its primary effect is to build up an ordinary state of police, and the secondary effect is chilling the rule of law. And so I pose a question to you, and of course I leave to our discussion at the end. Has institutional normality, as promised by Macron, been restored? I leave to our discussion. In these two slides, I've just reported some, in my opinion, important norms concerning regulation on internet in time of ordinary temporary. I like this expression, I use also in my book, and so I think that I can jump. One is the Article 21 of the directive above quoted, and then some example concerning the French law, and in particular I noted the Article 15. I jump also because of time. Now go strictly to my idea. I permit to draw a constitutional model of emergency law. Of course, it is my constitutional model of emergency law. It should be sketched to be compatible with the rule of law and the European legitimacy, as we've said until now. Here is this hypothetical model, and this hypothetical model, I stress on these things that, in my opinion, I suppose that I have to stay here because there is the microphone and it's quite difficult for me not to move, and I have pointed for first future. He must respect. You are. What is it? No. Can I close? Of course.
Maybe somebody wants to be involved in the.
Now close, then we can. Not one. The first feature: the respect of the rule of division of power, and of course the respect of the judicial review. Number 2, the respect of precautionality and proportionality. Number 3, it must have the expiration date, not as French law has done, with the possibility of a prorogation at certain condition, and then, finally, very, very important, a several judicial review. On the contrary, we have had by our Constitutional Court, French Conseil Constitutionnel, not for the Court of Justice, a very weak judicial review. I'm going to my conclusion. The final goal of law of fear is allowing the legal system to go back to its normality when the crisis is over. Insofar as the system, I use this expression that I like a lot when I thought I love it, is an elastic band, and it can go back to its original status, provided that we have respected the principle of precautionality and proportionality. Now there is a lot of bibliography that I have studied not for this slide but for my book. And I suppose that I finished. Of course, I'm available to receive all your questions that you wish to pose me during the discussion. And so we have to give the floor to you.
Yeah. Thank you very much. First of all, it's been really a groundbreaking introduction in which it's possible to look already at many insights that will be developed in the during the discussion. I would not now to take what has been said. It will be, I think, emerge and analyze later. But let's start with the first speaker, Fulvia Abondante. She is a lecturer in public law at the University of Naples, and she's working very closely with Professor Minico, many international projects, especially with regard to multiculturalism, freedom of speech, and freedom of religion. The title of her paper and then of her presentation clearly is Freedom of Speech, Social Network in the Age of Terrorism, a comparative analysis. I will be quite strict. Joanne is much kinder than me. I'm much more severe. 8 minutes, not more,
Okay.
because otherwise we will not have a discussion.
Okay.
Please, the floor is yours.
Okay. I am grateful to Professor Minico and Professor Pollicino to give me the opportunity of this to be here this morning. I start my presentation with quoting a reference by George Orwell novel 1984, a dystopic story about freedom of speech death. Preliminary remarks. It's important to clarify there is a connection to hate speech and glorify terrorism. Above all, there is one sometimes in the premise to the second. Hate speech has an uncertain definition. It's a very not homogeneous definition, and it's possible a lot of definition of hate speech included also glorify terrorism. It is important about online regulation. Constitutionalism on hate speech, balancing crimes of opinion and freedom of speech. It's not to all of you the problem about the limitation, compression of freedom of speech. Different approach from in USA and European countries about hate speech depends on the vision on freedom of speech. I jump these two slides. You know that there is the idea of a marketplace of ideas in USA approach. It's an end point and not start point marketplace of ideas. And it's important to underline that it's possible to change the idea of market of a place. You can see the 3 points on my slides, Holder versus Humanitarian Law Project. It's the last important jurisprudence in Supreme Court. The European approach on hate speech is, in general, very strong, different from USA. The European approach of freedom of expression, in general, is less optimistic than American one. Okay, US approach on freedom of speech in online world, it's important to start into Section 230 of Communication Decency Act. Online intermediaries that host or republish opinions are protected against a range of laws that might hold them legally responsible for what others say or do. Self-regulation approach. Generally, terms of contracts provide the block of removal violent or hate speech. See Facebook, Twitter terms of contract. Different definition of hate speech in terms of contract. The wider definition of hate speech, the broader the discretion of the provider in blocking or removing content. Terms of contract introduces also glorification of terrorism as an example of hate speech. Blocking or removing is carried by an algorithm or group of experts. Risk of private censorship. UA approach on freedom of speech. No governmental intervention, social networks, terms of contract are the only source to regulate the broad dissemination of hate. 2 steps, cooperation between social network and public authorities. 3 steps, third step, since 2016, the Code of Conduct countering legal hate speech on social network had pledged to remove all illegal hate speech after notification from public entities or direct reporting from users. A co-regulation model or new way of collateral censorship. This is a key point of discussion if you want. A recent German law introduced heavy economic sanctions against those social networks with a minimum 2 million members who don't remove illegal terms. EU Directive 2017-541, Article 21, before mentioned by Professor De Minico, it's important to underline the last part of this article that give the possibility to go under the judge after removal or blocking the content. Okay, law, fears and freedom of speech in Internet, Europe versus USA, collateral censorship according to definition of Bolkin, or versus private censorship, risk of both methods, chilling effect, control on content, balancing of rights by private actors, no transparency on evaluation, blocking or removing, silence dissent. New role for the judge, this is another question for you. Thank you for your kind attention. I hope I am in time.
Many thanks to Fulvia also for having been in time, of course, for the speech. Very.
Is it what remarks possible?
Not now.
At the end, all time to remark. Don't worry.
But if you have a really short one,
I have a really, really short one.
please do.
Okay.
So we will.
Second speaker of the laws of fear concepts. Maybe you could explain in a moment why the laws of fear. Laws, there was no fear. We have a new law that should make us fear. Maybe this just the term is not clear. So especially for me.
It's a very good.
What is the law?
It's a very good point, but I think it's a very general question that, in a way, needs
A very
to
long
be,
answer and discussion.
yeah, needs to
Don't worry.
be.
I give you all the reason for which not I, but Carl Sanson have used this expression. I completely agree with him, and then we can discuss. I don't want to waste the time now.
Sure,
The discussion, of course, you can repeat. Now, please take the floor, Professor Halmong and Mary Riesel. Just some few words to present you. Professor Halmong is a full professor of law at the University of Haifa and the co-director of the Center of Law, Gender and Policy. My compliment. She researches law and literature, law and the humanities, law and the digital culture, children's rights and legal feminism. Concerning Mary Riesel is an applied anthropologist based in Tokyo and working through CE Asia. She's a lecturer at the Risico University. A lot of publication also in this case. Just I quote the recent with Olmon, somewhere over the rainbow, artificial being, virtual terrorism, and the law in cyberspace, and other papers. Now, they will discuss together, I don't know how, but you organize, of somewhere over the rainbow, artificial being, virtual terrorism, and the law in cyberspace. Please. You want to, in this case, I suppose we can give, there are 11 minutes, okay?
Absolutely,
Okay.
even more.
We give 11 minutes and you can divide. That's okay?
We got already 14 minutes, but
No,
Because
14 minutes.
Let's keep 14.
Yeah.
Because we have count.
Yeah.
Okay. 14 minutes we are divided, okay?
Thank you for inviting us to this really exciting conference, and of course for organizing it. I'm going to go on with the line of dystopia thinking that Flavia just started with. Well, roughly speaking, constitutional law focuses on two main areas: the regime of the states and human rights. Both relate to utopian and dystopian thinking. As to human rights, the definition of human rights, I would even say the language of human rights, in most democratic systems is utopian in nature. It is wide and uncompromising, generally phrased, and unrelenting to the dictates of reality. The regime of the state and the governmental system, on the other hand, seems to imagine the worst. Dystopian scenarios, situation in which governments or authorities ignore rights, and also situations of terror, fear, and war. Our project here employs science fiction articulations to represent this eternal duality in constitutional law. Fictive narratives, like novels and films, give us opportunity to anticipate the right struggle that may take place should technology be augmented in certain direction. Struggles that, as we maintain, are not something that belongs to the future because they are already here. While helping us, this fictive articulation, while helping us to form understandings of fundamental concepts, such as what is the meaning of being human in our digital age. Science fiction is the natural habitat for such discourse due to the genre's tendency for speculation, allegory, and even prophecy. So I will very shortly review the first representation we analyzed, which I call the Blade Runner universe. And then Mary will talk about William Gibson's seminal novel, Neuromancer, and conclude. So here is the part of the Blade Runner universe. This is the first classic, the film from 1982. And then there's a very interesting short Japanese anime film that preceded the new film, in which a certain occurrence, which was really quest for survival, was named by the authorities a terror attack. And the film leaves us with the question, what exactly was the thing that we saw? And then there's the new film, which also corresponds with the former two, bringing up the question of a certain question, which I just review shortly. Here are the main questions that these three representations bring up before us. Where is really the law? How is it shaped and by whom? Where lies its source of authority in a digital environment? According to which criteria does it define who is human and what is human behavior? What is legitimate human behavior? How can one enter and reach it? How can one appeal to its influence? And the total lack of answers to this question sets the law as the great absent present protagonist of the menacing dystopia that all this representation present. And now we will go over to Mary. Thank you.
I would just ask you to raise your hand up to 6 minutes. I don't have a sense of time. Yeah, I'm saying in advance.
Time, and now you have 7 minutes. Go, full time.
I'm coming from a different field. I'm an anthropologist. I'm a virtual anthropologist. I work for internet companies, and I have the inside look. And the reason I joined here is because I think that the law is about 10 years behind what is really happening. And when I heard about this conference, I thought, okay, then the people who deal with it have to know where the situation is, because we are already in a point where we're beyond the ability even to say who is a criminal and how we define crime. And from this it starts. So I'm going to start first with a comment, I think, about the law of fear, because I think the law of fear is a development of social anthropology and social sciences that decided on this term of the culture of fear already in the Cold War. And the culture of fear started in the Cold War in order to make people be afraid, because it's very easy to control people who are afraid. And after 20 years of a culture of fear, it was very easy to start developing into laws and regulations and make everything much bigger and augmented in order to control the people. This is eventually the whole idea of fear, because people who are afraid don't think about rebellion. Now, years ago, during the Cold War, I was an editor. I was working on Neuromancer. I was actually the person who brought Neuromancer to Israel and translated and published it in Hebrew. And for me, it was science fiction. It was like, couldn't have ever happened. So it was really a fantasy. But what I've seen during those years is that those fantasies have come true. And I'm working inside cybersecurity and developing social networks and how people supervise these social networks. And the situation is very complicated. And it's very complicated because some of the questions I'm going to raise here is that, first of all, we are so advanced in genetic engineering and in mixing of humans and cyber creatures that it's very difficult to decide where is the boundary. Is which part of your body makes you less human? And why? Because there are all those people who run with artificial legs and win, and people say, well, that's not human anymore, but it's only legs. So where do we draw the line? Like, below the throat is okay to change, the brain is not okay to change, but why not? Because we know now that the brain is also very artificial. So we don't know what the human is anymore. And then there's this list of questions that are coming here that are raised because of that. First of all, that we are already in a situation where AI is going towards having consciousness and having self-awareness. And that's going to confuse us even more. And it's already confusing when the AIs are still just computer, but we are already confused where is the line between us and them. A lot of the crime on the internet is being done by AIs. So how do we stop AIs? Can we legalize that? What do you legalize? And this is where Gibson came in, because Gibson's hero was a cowboy that was blocked by the corporations, not by the government. But it is the industry and it is the money that has the power to control. And today, unfortunately, I feel it's the same. Companies with money, they, mildly saying it, they don't care so much about legal issues because they buy a lot of the politicians. So how do we succeed to detour that legally and to stop this process in order to regain the power of the law, in order even to create definitions and to set the boundaries? And all those questions come from the fact that soon we will not be able to define the human. I'm not worried about the machine, but I'm worried about how do we define humans. Then by that, how do we define what is a crime and what is not a crime? Because today only humans can commit crimes. What happens if a monkey or an AI is doing a crime? What happens if it's only a hand of a robot that is searching for your passwords or breaking the laws of privacy? Who do you abuse there? What if it becomes self-conscious and doing it for fun? So all those questions are raised again and again, and they're extremely complicated, and I think they are not part of our legal issues. In addition, there is, of course, the fact that a lot of what happens on the internet today, including all the laws you're talking about, are based on algorithms. Facebook is working on algorithms who are looking for negative words. Then how do we track that and how do we deal with this in a proper legal way? Because they are looking for the bad energies, targeting them, enhancing them, and manipulating them to reach other places. Then is this a crime? Because you can say, well, you know, it's algorithms. Then, of course, there is the problem of how do we deal with the dark net? I'm not sure how well you know, but the dark net today is huge. There are almost 1 million websites there. If there are almost 1 million, it means that the users, that's hundreds of millions, at least hundreds of millions of clicks all the time, whether it's the same people or not. But the dark net is the line that's crossing between reality and fiction, reality and the virtual, because they are using the net in order to make things come true. Not long ago, there was a young man in Australia that through the trafficking online succeeded to create a whole network of people who were kidnapping children from all over the world and selling them to sex dealers. But kids. So he was sitting in Australia and he could have someone in California kidnapping a girl only through the internet, because you can have access to cameras, you can have all this access into people's private houses. You can go to GoogleNet and you can see where is the house, if it's rich, if it's not rich, where the parents leave the house, when the house is empty, when the nanny is sleeping. You can surveil today every single person with Google, and that's legal. How come Google Maps is legal? See, I don't go so much into the difficult stuff, but the simple stuff. I can have a perfect psychological analysis of you in every single minute of your day just from what you have online, just from what you have, from access to your emails, from the photos you put. There are such complicated AIs that today analyze deeply every single facial expression. And from a single expression, you can know exactly where the person is and what they do. So I want to finish with cases. The first words of Gibson's Neuromance novel, because I feel that this is exactly where we are. See, this is closing the cycle for me. That's where I started from, and that's where my reality right now is facing. We are really standing in front of a dead screen, and we don't understand it. And I do think we have to close the gap between the different disciplines, which is why I came from Japan. We have to close the disciplines, because if we don't understand the psychology, we don't understand the virtual world, we don't understand the culture. Because here I can also add just the last sentence, every culture has a different fear. When we are talking about the laws of fear, so whose fear? How can we create something global? The Japanese are not afraid of the internet at all. They feel very safe. They don't understand the Europeans. We have so many legal issues with Europe, because like, what do they want? So the map is much more complicated, and we have to close all those gaps together if we want to do something. So, thank you.
Many thanks to Shurami, to the couple, cozy couple, Shurami and Mary. Of course, I don't make any comments, everything in our discussion. Please.
Thank you very much. Just to underline that this approach, interdisciplinary approach, law and anthropology, it's incredible, charming. I think we should really work on it, because it's like an horizon it's opening from a cultural and sociological point of view. I'm really struck by this approach. Having said this, I will give the floor to next speaker, Giovanni De Gregorio, University of Milano Bicocca, but he's working with me in Bocconi. His research interests are related to constitutional law and technologies, and we will see how the two speaks are connected. He will speak about powers, a new kind of powers, how digital and private powers are in a way a new challenge for constitutional law, not only from a legal point of view, but also from a cultural point of view. Giovanni, please.
Yeah, good morning everybody. It is a pleasure for me to be here. First of all, I would like to thank the workshop organizers. As Professor Pollicino introduced, today my presentation will deal with terrorism contents which spread online, and in particular, this is important to understand the role of constitutional states in order to tackle this kind of phenomenon. First of all, I think that we should now focus on these three elements. We should now understand the relationship, in particular between censorship, terrorism, and online platforms. As you know, terrorism and censorship are two whole phenomena. We know how constitutional states have dealt with censorship and with terrorism. We have a lot of experience of them. But what makes censorship and terrorism today very relevant is the possibility that internet have created in order to spread this kind of illicit contents. So the problem is that why online platforms are so relevant is that because they have autonomy even to decide about censorship, regarding private censorship, as has been already said, and on the other hand, even in terms of terrorism, to define whether they should decide, according to the notice and takedown procedure, to strike down a content, if a content is an act of terrorism or not, if a video is a terrorist video or not. This is an idea which belongs to the platform. So here, what is the role of constitutional states? So we are in a really paradoxical situation for constitutional states in terms of regulation of online platforms. Because on the one hand, constitutional states are bound by the respect of fundamental rights, and so they need to balance and respect the freedom to conduct business in the EU of online platforms. On the one hand, if you want to look this element under a new US perspective, this you can look at the protection of online platforms in terms of freedom of expression. So on the one hand, there is the problem to ensure that platforms can develop freely their digital services. However, on the other hand, we have the issue of terrorism, the issue of public security, and the need for states to act in order to reduce this risk, and in particular the usual tool that constitutional states can use is a regulation. However, even monitoring obligation to online platforms or surveillance or public surveillance directly creates a lot of issues of freedom of expression. So the paradox consists in how constitutional states can avoid to hinder freedom of expression of the users, on the one hand granting autonomy and on the other hand regulating online platforms. This is the very current framework, and I would like to discuss with you two very recent examples, both in the EU and the US framework under a comparative perspective. So in the EU, very recently, the European Commission has started a new strategy in the field of regulation of online platforms, in particular with this recommendation that I invite you to read because it's very interesting in this field. It is a recommendation, so it's as an European instrument, it's a non-binding measure. But however, this is not, in my opinion, is not so important because this is a very changing in the approach regarding the strategy of regulating online platforms. And in particular because the EU Commission, even through a soft law strategy, has introduced a kind of regulation of the autonomy of online platforms by impacting on their decision-making process. By, for example, nudging online platforms to transparency obligation, even I said before are not mandatory, but not only obligations of transparency, but even of the redress mechanism. And this is very important because this recommendation deals also with terrorist contents, in particular oblige online platforms and invite online platforms to remove terrorist contents within 1 hour after the receive of the notice by notice providers, which however are qualified notice provider, are not users but are public actors such as Europol, European agencies and national states. This is very important because it's a change of paradigm in the notice and takedown approach. Moving from the EU to the US, because I have no time to deal with all the elements of this recommendation, we have in the US we have a very different approach. As you know, I think terrorism is a very popular topic in the US. However, the US has not taken the path to regulate the platforms, but they have really focused on surveillance. If you look at the US Patriot Act of 2001, you can see an approach based on public surveillance. So instead, regarding the role of online platforms in the US, it was followed a very different path in regulating online platforms, and this can be explained by looking at the paradigm of freedom of expression in a comparative perspective between the EU and the US, which is very different, and this is why online platforms in the US under the First Amendment can exploit their autonomy more than even in the EU framework, as the European Court of Justice case law demonstrates. So this is a very different framework. So this is a very different framework of protection, both in the EU and the US. So I would like to even add you that recently in the US, the Sesta Fosta package, which was recently adopted, even in this case has introduced maybe a new season for the liability of internet service providers in the US. It's a very recently package that concern the sex trafficking online. It not deals with terrorist contents, but however, there's the liability of online platform regarding a specific contents is a very changing paradigm in the US regarding the regulation of online platforms. However, what can let's turn back to our first question. What is the role of constitutional states in tackling these contents? And I think that is very important before to think about terrorism online and the spread of illicit online contents to focus before on the regulation of platforms, because we know that platforms play a very important role in spreading this kind of contents. It is clear that platforms are not the only concern regarding the regulation and the problem of online terrorism, because there is even the problem, even more importantly, of the deep web and so forth. But in this case, we should ask whether states should be concerned before to regulate online platform instead of think about dealing with directly online terrorism contents. So, as we know, as the paradoxical situation that I can try to explain you before, we have two different perspectives. On the one hand, we can decide to impose ex-ante monitoring obligation to online platforms and have some consequences on freedom of expressions of the users and public surveillance, even for privacy. Then on the other hand, we can let the autonomy, we can continue following this path from 2001 and given more autonomy to online platforms and hope and really have a huge expectation to the free market. However, the problem is that we need a more balanced approach. We need a more balanced approach even under a EU constitutional perspective, and maybe the path that the EU is following now through regulating the monitoring obligation of online platforms, but their decision-making processes through transparency obligation is a more really proportional approach that, in my opinion, even in the US framework will be followed. Thank you.
Many thanks, because as I said, there is an interesting link between the two last speech. Autonomy, nudging in order to take again a sustain, obligation to obey, and voluntary obedience. New powers emerging, a new challenge for constitutional law. We will come back to it. Joanne, next speak.
Now, Maria Francesca Di Tullio can take the floor. I don't know how to say before concerning Maria Francesca. She is my PhD student. She does a lot of things, thesis in constitutional law, substantial equality and online participation, representative mandate, and horizontal subsidiarity. Research stay at the University of Paris, Pamplona-Assas, but also speaker national and international congress. A lot of essays, trade agreement, internet governance, open data, privacy and big data. I'm just quoting the most recent, most important, free enterprise and freedom of information, political question doctrine, and I stop. The paper now is on the internet and the non-nationals. Is the net a tool for inclusion or exclusion? Give us your answer.
Thank you. Of course, thank you to the organizer for this important occasion of discussion. So today I will talk about internet and terrorism, but not in a general way, but just as an example of new paradigms which are diffusing themselves in global governance. So they're both global phenomena which brings with them internationalization and participatory decision making, so in processes of real making. My fundamental hypothesis is that these forms do not pose an end to discrimination in nationality, despite their global forms of rulemaking, and despite being participatory, they're not equal, but they only involve strong actors, such as, for example, we'll see businesses, big corporations, etc. So probably we will see that the real important thing in participation to these global processes of regulation is not nationality, but rather economic power. So I will first show how the harmonization of the internet law has been conducted more through trade law than through human rights. And secondly, I will try to confirm this impression by examining how discrimination still remain in the regulation of the internet. And particularly, I will focus on counter-terrorist online measures and bulk metadata surveillance. So I will try to make some proposals on how participation can become more equal and so more inclusive. As to internet and trade law, we are used to think of it as separate questions, but of course they're getting more and more interlaced, because as it has been said, as more businesses, models and practices move onto digital platform and data becomes increasingly shared and exchanged on an international scale, its relationships to international trade intensifies. This means that, of course, the internet is increasingly covered by free trade agreements, which are a new kind of legal source, which have the aim to harmonize law. Because as we all know, legal fragmentation is an obstacle to commerce, an obstacle to circulation of goods and services. So we have this new kind of legal source which try to harmonize those laws. Why I say they are new? They're new both as to procedural sides and as to contents. As to procedures, we see that they are not state regulations and not private regulations, but there are rules where private negotiators and advisors sit at the same table contracting with states and governments. So we have also new forms of institutions. And this contracting are also secret, not only to the people, but also to the parliaments themselves. While as to contents, we see that while democratic juridical systems are usually based on fundamental rights, so they consider fundamental rights as a general rules, which can be limited, as Professor De Minico was saying, only in few exceptional hypotheses. In this case, we have this new kind of legal source, which is centered around free trade. So free trade is the rule. I don't have the time for a full explanation of this, but I refer to the paper. Free trade agreements are centered on the value of free trade, and human rights are an exception to free trade. As we all know, this is not irrelevant in law, because exceptional rules must have a narrow application, while a general rule is something that can be always applied in an extensive manner. So we see that there is a huge internationalization of internet law. And then we can wonder if discrimination disappeared with this kind of globalization. Well, actually, I don't think so. And I can take just an example to explain this, which is something we know very well since Snowden's revelations. I'm talking about the bulk metadata collection and surveillance. But I will not speak about the phenomenon in general, but only of its profiles which reveal discrimination. So how does that determining work? It is a statistical method which identifies some characteristics and behaviors which are usually connected with a crime. So people who have this kind of characteristics are automatically suspected of being a criminal, so only for their particular personal characteristics. And we can easily imagine who this person is. Of course, Arab people of Islamic religions. So these people are being discriminated, are being suspected only because of their personal characteristics. Moreover, such predictions tend to self-fulfill, as it has been said by Mantelero. So the fact of spying certain categories in a special manner also means that we will discover more crimes within that category. But even if the crime rate is not really higher, the main fact is that we control them more. And finally, there are some laws which actually actively discriminate towards foreigners, because they exclude them from some privacy protections. So we can try to find an explanation for such contradictions, and in my idea, this explanation is in the economic factor, because actually I think there are some problems in the democratic construction of citizenship, which has never become totally real. because democracy considers citizenship as a space of equals which share same values and so a general interest. Then participatory rights are given to citizenship because they are able to interpret these general interests. But actually, Western society are not that equal. So there are class struggles, social conflicts everywhere. And in fact, some people have never been able to participate, even if they are citizens. So we noticed that citizenship has worked better in an exclusive way to exclude foreigners than in an inclusive way. And since the economic factor, we know it's the most important one, if we look at how to democratize participation, I think we don't have to come back to the state model, which would be impossible, but we shall grab the occasion of these new global and participatory forms of rulemaking, but to make them more equal, which of course requires a positive intervention of the state, a positive material intervention, also in terms, of course, of an economic help. So thank you for your attention. For any comments, you have my email, or we can discuss after. Thank you.
Thanks to Maria Francesca also for her special effect for slides. I envy her a lot, and also for the merit. Just underline important point when she has said this bulk collection of our metadata without safeguard for us. We don't have the right to access to this data, and we don't have an oversight, an independent oversight authority to whom we can apply. Everything then in our discussion. Okay, please. Next one.
The next speaker will be, if I'm not wrong, not mistaken, Maria Repice, University of Naples, Federico II. She is also the professor of the Minico school, and as you can imagine, her topics are related to communication, freedom of speech, and now she's focusing from an interesting perspective on big data and not discriminatory movement of the big data. In this case, she will focus the paper and the presentation freedoms, it's interesting, the plural, and the artificial intelligence in time of terrorism, in order to understand how freedoms could be protected, even challenged by a virtuality that is not at all virtual, but is really, really substantial and I would say real in the effects, in the behavior, as Mary showed us. Please.
Okay. Good morning to you all. To start with, I would like to thank the Professor Pollicino and the Minico for this exciting opportunity. Thank you. My speech consists of three parts: privacy in the age of artificial intelligence, the advent of new technologies and the reasonable expectation of privacy of big data, and third, the European Union shapes the future of AI with a regulation, GDPR, General Data Protection Regulation. So, terrorism of ordinary times raises several questions related to the compression of fundamental rights, a massive control of people's private lives, a departure from right of every individual to informational self-determination. With the advent and rise of technological innovation, the Internet of Things and artificial intelligence systems developed by governments and private individuals increase the risk that machine-to-machine decisions are taken through automatic choices, determined by profiling of users. Today, the confidentiality stretching its meaning should cover these spaces. As Rodotà said, Rodotà was an Italian jurist, transforming itself into protection of existing choices against public control and social stigmatization, or as the demand for social instruments that protect us from the risk of being simplified, objectified, and judged out of context. So privacy became requests of individuals to control their data on the net through new protection tools. Its aim is to protect the dynamic and emerging subjectivity of individuals from the abuse of commercial and governmental actors who are interested in making individuals and communities fixed and predictable. AI raises questions concerning the protection of privacy on big data. The information that is collected and crossed every day becomes, in informational society, hypersensitive data that affect the explication of users' freedoms to the point that they themselves constitute the core of those inviolable fundamental freedoms. In fact, the data can reveal if a person will have a heart attack and can therefore determine the price of the insurance premium, or may predict that a particular person will fail to repay a mortgage loan, causing the bank to deny them financing. The prediction would degrade self-determination and may prove to be incorrect if the data on the basis of which it's made are not correct, with serious consequences of the fundamental freedom of individuals. So, American jurisprudence, in its many rulings, has shown that privacy covers everything the owner assumes to be private, even if physically released from its material availability. Okay. The Fourth Amendment covers all cases in which there is a physical or immaterial entrance into the area occupied by a person. Let us collide on this point the dating of the Supreme Court of the United States, Wallen versus Roe. In this case, the court considered that the collection of information affects two privacy interests, an individual interest in avoiding disclosure of personal matters. In this specific case, the court found that the legal guarantees adequately protected the interest not to disclose personal information, and an interest in independence in making certain kinds of important decisions. In this regard, he stated that the decision in question was how much conditioning would be derived from the subject who was supposed to take it. So if we want to apply the reasoning of the court of the object of our investigation, we will verify the presumable maintenance of data in the private sphere by its owner, the interest not to disclose their data, and the interest in making independent and autonomous decisions of the transfer of data. The fact that in using the smartphone, the subject accepts that the information entered in it is saved on servers located in an area outside the smartphone cannot mean that the subject wanted to give up their privacy. The daily use of electronic devices does not annul the expectation of protection of those who use it. Then, the free action of individuals would risk being threatened by a sort of data dictatorship, which, if today may seem far-fetched, could will be adapted to the authoritarian drift of a democratic state. To hide the individual in extrema ratio, it could renounce the freedom to choose the contents to be accessed and the sites to visit on the net, self-limiting its freedom of expression for fear of being spied on. The risk is to turn a person in a mere object to be manipulated with, nullifying every fragment of dignity. The dignity assumes the form of freedom of self-determination. The prediction would replace self-determination, and therefore the black box of the individual, which today gathers all his data, would become the new hard core of the individual's privacy, which is based on the principle of modern constitutionalism. You can see Italian declaration at Articles 5 and 6, whose writing was attended by Professor Giovanna De Minico. The European legislature seems to have taken some step in this direction, with Regulation 2016-679, fully applicable from 25th May 2018. We generally include some provisions for those who treat personal data of European citizens, including those outside the European territory. The regulation incentivizes companies will be able to take to challenge of privacy compliance, to compete in the market and strengthen consumer trust. The new privacy is also fundamental for the capacity for innovation as a non-price dimension of competition. The European legislator is moving in the direction of securing the fundamental values on which democratic society are based, according to NICE Charter, and at the same time to promote the free circulation of data, as recognized by Recital 7 of regulation. The regulation sets a number of principles that can be adapted to the context of the AI. First, the transparency of the algorithm that makes the processing of personal data in which their data are involved. Secondly, the accountability of the data controller and the obligation to assess the risk that the treatments involve for the freedoms and rights of a person, DPIA, following degradation, data protection impact assessment, and to adopt technical and organizational measures adequate to the risk involved in treatments, as well as security measures. And finally, data portability. This system will need to be developed in ways that allow for the control and the predictability of behaviors, with human intervention to interrupt treatments or deactivate the machines. These principles are translated into the need to insert into the language of algorithms ethical principles that help the machines decide, applying the precautionary principle. These principles should also be extended to the field of AI to develop a preventive assessment of the impact of AI algorithms on the basis of available practices in order to link the new AI products to this type of assessment. Therefore, privacy by design should be the starting point for regulation and enforcement based on the protection of non-negotiable rights and prevailing on market logic or on public security, such as self-determination. For this, the owner and the whole chain involved in treatment respect the principle of loyauté defined by the CNIL, a French supervisory authority. In conclusion, there should be human and clear international, not only European rules, and a responsible authority for processing the data behind the scenes who are to be held accountable. Any regulatory and non-regulatory framework will need to both make humans secure, respect for fundamental rights, and not kill innovation. New technologies and AI could not only positively influence the relationship between the central state and citizens and create opportunities for simplification of public services, but above all to provide citizens with tools for controlling and disposing of their personal data. This approach will enable individuals to safely organize and share their personal information at a machine-readable level. A basic goal for the creation of this standard is to educate policymakers and commercial actors and to draft of a supranational constitutional framework. Only with a good foundation for developing a regulation that fits with different interests, we could ensure and encourage the innovations that achieve specific societal goals, such give user control, democratize powerful technologies, and make sure they are used for the public good.